We'll get started. Senator Jones, you've got Senate Bill 299. What I'll do, Senator Jones, is ask you to give us a brief explanation of the bill, motivations behind it, what you hope to accomplish. What I'm going to do then is call on Chairman Setzler, Chairman of the subcommittee, to give a report on the subcommittee's actions, and then we'll go to questions from there.
Thank you, Mr. Chairman,
Please.
and members of the committee, for the opportunity to present Senate Bill 299. The history of Senate Bill 299 came out of an experience of a kid, Eli Mahone, up in Morgan County. This kid was 14 years old. He brought inadvertently a 2.5-inch knife to school. He turned the knife in to the principal at 8:27 a.m. Before noon, and the principal said it was okay, sent the kid back to school. The kid got really nervous, called his parent. Parent came and picked him up, and around 11 o'clock that afternoon, he got a call from the sheriff department. His mother did, to either bring your kid down to the sheriff department or we're coming to pick him up to arrest him. This kid, who was 14, was arrested, in my opinion, for trying to do the right thing. The legal limit for a knife was 2 inches. He had a little 2.5-inch hunting fishing knife up near Lake Oconee, and I'm a friend of the family, and that's what they call me. And upon further investigation, I found that there was a judge in that region up there that had a standing court order in place that for any kind of weapons violation allowed the authorities to take a kid directly from school to prison. And that's what happened in this particular case, where Ms. Hensler experienced her child being arrested, been handcuffed, been put in the back of a police wagon and carried off to Sandusville Youth Detention Center. That was on a Thursday afternoon. I got involved on Friday, and working with Senator Grant, who represents that area, we were able to get this kid out of prison. Senate Bill 299 does three things. The first thing that it does is that it prohibits judges from having a standing court order. The second thing that it does is that it changes the juvenile code section to treat really the first offense as a delinquent act where there's no intent of an assault. Of course, there's an exclusion in here for any kind of dangerous weapons or assault weapons of that nature. And that's in Section 2. Section 3 of this bill changes one word back in Section 3 from shall to may, and the intent of that change is to give a lot more discretion to the judges. Senate Bill 299 was patterned after a lot of the work that was done over in Clayton County by Judge Teskey, Juvenile Judges Council. I've been consulting with him extensively on this particular bill, and I've vetted the bill through the Superintendent's Association, other teachers' associations, and as many organizations out there as possible we've vetted this particular bill with. And it's my hope today that I can get a favorable opinion, favorable decision from this particular committee.
Well, I want to personally applaud you for bringing this bill forward. Over the course of time, I represent a portion of Cobb County, Smyrna, and we've seen our share of situations where a zero-tolerance policy has really defied common sense. The Tweety Bird chain situation that you may have heard about, there was also a situation well, not necessarily in the context of any sort of weapon or perceived weapon, but we had a situation where a child brought a bottle of wine to his French teacher for Christmas. It was obviously a family gift, and was suspended because of violation of the alcohol policy. When the law gets to a place where common sense is not kicking into full gear, and administrators are either not exercising common sense themselves, or if the law doesn't permit them to exercise common sense, which is, if it's too restrictive, then shame on us to the extent that we have responsibility. But through this bill, I think we'll be able to bring a little more common sense to that process, and that's my hope, and I appreciate your bringing the bill forward. I know there may be an issue or two, but I feel confident that we'll plow through it and get to a common sense outcome. So with that, let me recognize Chairman Setzler for a subcommittee report. Chairman Setzler.
Mr. Chairman, we took this up in subcommittee last week. The subcommittee voted unanimously to send it forward with a due pass recommendation. There was not extensive testimony on this bill as there is on many of the bills we take in subcommittee, but I think the subcommittee could be characterized as supportive of it as written. I think there's been some language recommendations and some issues that are going to be proposed today, but it came out favorably from subcommittee too. So. Mr. Chairman, did you want me to characterize it any further, or?
I mean, just any issues that the subcommittee may have. I know, let me put it this way, I know an issue has arisen, and it'll come up in the Q&A here regarding Section 1. The language of whether or not there shall be a detention or a child placed in shelter care by virtue of a standing court order. Can you get into what the subcommittee heard and what the reaction was on that at the time?
Well, again, the conversation was not as extensive as is often the case in our subcommittee. I think the policy question centered around should this apply to school context? Should it apply more broadly outside of school contexts? Should there be a prohibition for standing court orders with respect to schools? And then how does that apply in other situations? Again, there wasn't an awful lot of conversation about it. I think that was kind of chattered about in the halls before and after the committee hearing. And I think the subcommittee was comfortable with where this put us. But I do think there have been some folks that have come to the table since our subcommittee that have brought some ideas that may be relevant today. So beyond that, we did look the other sections. Plowed through the distinction in 51 through 58 with respect to any weapon requiring an assault, the other weapons being firearms or dangerous weapons. There's sort of being a distinction there made, but beyond that, Mr. Chairman, I think we'll center around the Section 1 discussion that you're aware of.
Thank you. Questions for the author, Chairman Ramsey.
Thank you, Mr. Chairman. And I don't know if you have somebody here that Judge Teskey's not here, is he?
No, he's not.
Okay. No. Okay. We may need a little help with this one. In Section 1, what a number of us are struggling with is what is a standing court order. What I'm concerned about here is kind of, I mean, in the situation that you're describing, I understand where you're driving at from a policy perspective. But where my discomfort is there a scenario that we're not thinking of, or that in which we are going to preclude the detention of somebody that is truly dangerous before there's until such time as you can hold a hearing? And it just seems the way it's drafted, it's a little bit vague, and I was just hoping you could speak to that point a little bit for me.
Sure, be glad to. And I can tell you the conversations that I've had as well as legislative counsel, and I'm glad that Jill Travis is here, who authored this legislation for me in legislative counsel. The intent that I brought to legislative counsel was to prevent any child from being sent off to a detention center without having some type of a hearing. I mentioned the case up in Morgan County with Eli Mahone. There was a standing court order in place, and since that time, in many conversations with Judge Tasker, he's explained to me that typically juvenile court judges do not have standing court orders in place. As a matter of fact, after I introduced this bill, I got an email from Judge Philip Spivey up in that part of the circuit, who explained to me that he had removed his standing court order that he had in place. His intent was to make sure that any child that brought any kind of dangerous weapon was immediately detained. And I understand that, and I don't think this bill in any way weakens the ability of law enforcement. It certainly doesn't weaken the ability of the school systems in any way to detain kids that are presenting harm to themselves or to anyone in the system. But the intent originally was to prevent kids from being sent to prison. And this is a code section that Judge Tasker supported extensively. It was modeled after a program that he has up in Clayton County that brought pretty much 3 stakeholders: the school system, the resource officers, and the judges together. And between them, they were able to cut detention down by about 50% in Clayton County by having this type of program in place where kids will work with in a home setting or in a school environment rather than putting those kids in a detained environment. And that really is the intent, and it really speaks to the work that he's been doing, the good works he's been doing over in Clayton County.
Well, I guess I still a couple. I mean, the way this is drafted and the way I read, you're accepting out in 151145, 151146, and 151146.1 kind of sets out all the ways that a juvenile can be detained,
yes.
And it ranges from protecting their safety to the child has committed an offense by which they can be for which they can be arrested. They've committed a crime. What I'm concerned about is kind of the ambiguity. The way this is drafted is we're going to limit the ability to detain a juvenile who is committed a crime. I mean, what you're intending, the way I understand, you're intending this only to apply in instances where a standing order is in place. If they're being detained for the other reasons that are prescribed in here, it's not your intent to preclude them from going straight to detention, right?
That is correct.
Okay, so if a juvenile commits a crime and they're being arrested pursuant to the arrest powers of the law enforcement agency, you're not trying to preclude them from from being detained prior to a hearing, correct?
Absolutely not.
Okay,
Absolutely
so
not.
this is only meant to apply when there's a standing court order in place. I guess and several of us have kind of been struggling with this a little bit and I'll defer to some more questions, but I think there may be a way to word this a little bit better where it's clear and we're not leaving this up to the I guess the grammatical interpretation of people out there that are in practice. So I'm going to look at it a little bit more, and I may have some more follow-up questions, but I'll defer to the other members of the committee to ask any questions they may have.
If I can, Mr. Chair, so it would be a good time to ask legislative counsel for her opinion in terms of how Section 1, lines 15 through 17 have been written.
We can do that. I think it's really going to. I think everyone sees where you're trying to go on. I think there may be a divergence of opinion on does the wording of the section right now accomplish where it is you're trying to go. I read it in terms of by the operative term, the most important terms, by virtue of a standing court order. I see that as modifying all the words before that in terms of its statutory construction. Does not mean it couldn't be better worded, but that's how I see it in terms of what's modifying what in the context of the plain meaning of the statute. With that, I'll defer to counsel if she wants to weigh in. Let me ask you to bring the microphone to you. So, thank you.
So if there's this is solely if there's a standing order now. That's not to say that if the child committed a murder or committed an aggravated assault, they're all going to be scored on a DAI, and if the DAI puts them in custody, this isn't going to have any application. If there's a situation in the household where DFACS needs to be involved and the child needs to be detained for his own welfare, this isn't going to prevent that kind of detention. The only detention this is meant to prevent is where there's an automatic standing order and somebody would have otherwise been released. And the standing order is preventing that release and holding that person, which was the circumstance that Senator Jones was trying to prevent. So it's a very narrow application.
Let me ask Chairman Ramsey if he wants to respond to that.
Well, what I'm still wrestling with is and I don't think automatic standing order is defined anywhere in the code, is it?
I don't know, but I know from my involvement in this bill that the number of jurisdictions that have standing orders relative to this are very small.
Well, and I guess that's my prime source of discomfort right now is I've talked to several. I'm an attorney. I don't practice in criminal law. I've talked to several people that do, and they have no idea exactly what standing court order means. And is there a scenario where where one could be in place that is truly in place that's necessary to get at a person that's subject to that order, and we're 100% precluding them from being detained until we have a hearing. So I guess maybe there's a practitioner out there that can shed a little bit more light on what an automatic or what a standing court order is.
From my years of practice, a standing court order was something that the judges came about that they entered, and it was in the clerk's office, and the people that were interested in it knew about it. And I know Judge Boggs is here; he probably can explain that's how. I mean, we had standing court orders in my jurisdiction, and I think that's a pretty common term of art.
I appreciate Ms. Travis opening the door to put Judge Boggs on the spot. I was waiting for that opportunity, but I always look for someone else to open the door, and I thank counsel for doing that. Judge, I mean, obviously you're not here for this bill. We're not asked to prepare for this, but to the extent that you can shed any light on this, we'd appreciate it.
Thank you, Mr. Chairman. I've just read this for the first time. I will tell you the council of Strict Court Judges has no opinion on the bill, but I will tell you that I think it's a matter of nomenclature. What Ms. Travis is referring to, and I think what the Senator is referring to, and what the Chairman is referring to, while here is referred to as a standing order, is what we judges would commonly call a local rule. Local rules are provided for in the Uniform Superior Court rules. I suspect they may likewise be provided for in the rules that apply to juvenile courts and such. I only deal with juveniles who are charged with felonies, so I don't deal with detention hearings. However, I agree with the analysis that it does carve out an exception only with respect to waiving the detention for purposes of when it's been allowed under a standing order or standing rule, or what I call a local rule. You need to be aware that the Supreme Court now no longer allows local rules. Local rules are now a thing of the past, and we judges that enact those, and they can be enacted by a majority vote of the judges within the circuit. They are now only for purposes of procedural matters. Setting up a drug court, for example, used to be by a local rule. Now it's done by a procedural rule that has to be passed and cleared by the Supreme Court of Georgia. We send those to the Chief Justice. They approve those, and then they are deemed a local rule, if you will, and they're on file with the clerk's office for any practitioner that wants to see a copy of what your local practice might be, how you might have deviated in your circuit from the statutory language. And so I suspect that what this juvenile court judge had was analogous to a local rule and passed by a majority vote of the judges in that circuit and deviated from the standard rule, which would require in these instances that individuals are not allowed out of the detention center until such time as they have an informal detention hearing. That is the general rule. This carves out an exception. But I don't know that you need an exception in as much as local rules are no longer allowed, or at a minimum you ought to include probably the word local rule, or I'll get you the new rule, the new word. I can't remember what it is. I just sent one to the Supreme Court about 2 weeks ago for approval. But there is a procedure by which all this stuff has to be approved. And I'm couching my entire comment on a presumption that may be inaccurate, and that is that standing order is probably analogous to local rules.
If Chairman Ramsey, yes, sir.
Yeah, well, and I think that to a degree makes my point. We've got a judge that isn't sure whether or not it is analogous to a local rule, and that's a new phrase that's been brought into this. I totally agree with what you're doing with Section 2 of the bill, but I personally am not comfortable unless we can figure out a way to clarify this a little bit. Supporting Section 1 of the bill.
Let me ask you a question, Judge. I mean, when you say the Supreme Court invalidated local rule, was that by virtue of a decision on a case, or just administratively, or
administratively sunset? I can't give you the exact date, but I want to say December 31st of this year.
So I mean, if that's the
local rule sunset.
Okay, well, if that's the case, then.
But however, January 1st of next year, you can enact new local rules. All the old ones sunset.
Okay.
But there'll be a provision and a mechanism by which you can still have local rules, which I'm assuming are the analogous to standing orders. And my only suggestion would be that you use the language, and I can get it for you if you can let me have the Georgia code for a minute. I can get you the language, but you ought to put in here, just so there is no confusion, Mr. Chairman, between standing order and local rule, that what you're attempting to accomplish is to ensure that the judges of a circuit don't deviate from the statutes authoritatively by doing what they're allowed to do by passing a local rule that holds these individuals in detention when they ought to be let out pending a detention hearing. I think that's the purpose. I don't have an opinion one way or the other, but if that's what you're trying to do, make sure you include the language that would encompass any mechanism by which they could do that. Standing order, if that's what they call it, local rule, procedural rule, or other rule of the judges of the circuit.
That's very helpful. We can certainly do the research to make sure we match it up properly. Mr. Levitas.
Thank you, Mr. Chairman. And my questions or comments are along the same lines. I guess there's two issues that I have. One is whether the sweeping language of notwithstanding all the code sections that are listed at the front are necessary, because that does capture the other crimes that we've talked about not capturing. So my first point would be whether or not we could narrow the notwithstanding language to capture the specific conduct that we're talking about that we don't want to require detention hearing for, number one. And then number two, I think that we not only need to move the part about by virtue of a standing court order up to the beginning, but maybe flesh out more particularly that the standing order relates to an individual not being able to be released prior to an informal hearing. And the reason I say that is I guess I don't, Mr. Chairman, with all due respect, share counsel's or your opinion that that modifies everything. In fact, I think that one reading of this could be that you could never detain them unless there was a standing order and unless there was a petition filed in that case, because the way this reads is, notwithstanding these code sections, a child may not be detained or placed in shelter prior to the hearing on a petition by virtue of a standing court order. Well, in a jurisdiction where there isn't a standing court order, you would never have a petition by virtue of a standing court order, and therefore you'd never be able to detain them. And whether that's right or wrong, I think it's certainly susceptible to that interpretation. So I think in line with Chairman Ramsey's comments, at the very least, I think we need to move that back to the top and say in jurisdictions where there is a local rule that would otherwise, prevent a juvenile from being released, and notwithstanding the provisions of code section so-and-so relating to the specific instance here, a child may not be detained or placed in shelter prior to that hearing.
And reasonable minds can differ. I would say that where there is no standing court order or whatever the proper nomenclature would be, I'd say that section just has no applicability, period. That being said, better to get it more specific than less, to allow less room for interpretation, credible and otherwise. So, I think we're on the same page. We want to get to the same place. It's just a matter of how we structure it. Mr. Mangum.
I will defer until my distinguished colleague, the chairman of that committee, because he's on something. I'll defer until I'll go after him because he may cover it.
As a practical matter, Senator Jones, I think what we'll end up doing, out of an abundance of caution, is we'll go through questions here just to make sure members' concerns, and there may be more than just on Section 1, are addressed. And then what we'll do is we'll take it within and come up with a clean sub and consult with you on that, and then go forward at our next meeting just to make sure we dot the I's and cross the T's. So just want to make sure that's clear. We do better to take our time than to legislate on the fly in this room, that's for sure.
I appreciate your diligence, Mr. Chairman.
Thank you. I appreciate that. Mr. Sessler.
And Mr. Chairman, I don't know that I'm moving the ball forward at all here, other than to perhaps suggest some language. I think a wording of this that I hope would take away any concerns, notwithstanding Representative Levitas' concerns about the term notwithstanding. But notwithstanding the provisions of code sections listed, insert no local rule or standing court order shall require that a child be detained or placed in shelter care prior to an informal detention hearing. In essence, it's saying it prohibits a local rule or standing court order from requiring something. I think it reframes the sentence in prohibiting any order from stating that this shall be done. I think that it does kind of shift the grammar around, and I'd be prepared to offer that as a clarifying amendment. It doesn't address Representative Levitas' concerns about the referenced code sections. I'm not sure I'm convinced that needs to not be there, because I think we first want to do no harm here and don't want to move the ball backwards any with respect to law enforcement's ability to detain people that need to be detained. I think the focus here needs to be on controlling and limiting the power and the effect of local rules or standing court orders, and make sure that the grammar of the appropriate language here is focused just on that. and that we not have the unintended consequence. So at the appropriate time, I'd be prepared to offer a friendly amendment.
Ms. Abrams.
First part of what I wanted to say, he's just said, so what he said.
Okay.
But
well said.
Thank you. But I think the second part goes to Mr. Levitas' concern, and I would actually push back a bit, because I think the mechanisms for accomplishing any detention of a child under those provisions is provided for via other means, and so I don't think that there's any obstruction of justice by leaving these code sections in. And what I would ask for some testimony that would demonstrate sort of the opposing argument, because for my questions, in order to detain a child, you could have an arrest warrant issued, you could have other things that are done that are not court orders and that are not local rules. And I think this is a fairly narrow, as both the Senator and Ms. Travis have pointed out, this is a fairly narrow and rarely used provision. But what we're trying to do is make sure that we don't allow children to be detained without the virtue of due process that this could provide. And so I would push back a bit on Mr. Levitas and say that I'm not certain that those provisions, those code sections, despite the gravity of the crimes detailed in those sections, that we don't have alternate mechanisms for dealing with them that have nothing to do with standing court orders.
Mr. Franklin, and then Mr. Levitas, if you want to.
Great, thank you. I appreciate you bringing this. As Chairman Golick pointed out, we've had some pretty strange cases in Cobb County, and one just down the street from me, a honor student at the high school was having some trouble with his old clunker that he was driving, and was constantly needing to repair his radiator hose, and had a kitchen knife locked inside the car in the back seat with his new radiator hose that he was planning on getting put on there. Someone walks by the parked car in the parking lot, sees it, freaks out, then he's arrested and so forth. Honor student. And which brings me to maybe a possible improvement on the new language starting on line 51, where if he is continuing having radiator problems, and on his second kitchen knife locked in the car, he would still be captured under this.
That's correct.
And because I like what you have on 54 and 55 together with an assault. Obviously, there needs to be some discretion, and if his kitchen knife is locked in the car in the parking lot, he's not threatening anybody with it. Then I'm not that concerned how many times he has that in his locked car in the parking lot, because it in and of itself is not an issue. And I don't know if you'd consider just maybe starting line 51 with constitutes the adjudication of delinquency based on a violation of 1611-127.1 involving these things, and not really needing the second or subsequent, as long as it does involve either the assault, it is a firearm, or the dangerous weapon. Would that be something you would consider?
From an abundance of caution and the testimony and what's been presented to me with by Judge Teskey and all of the other juvenile court judges I've consulted with, typically when a child gets in trouble the first time, they said it's very, very rare for a child to get in that same type of trouble a second time. As a matter of fact, they said it practically never ever happens once that child is disciplined the very first time. So I think in this particular case, that once that was brought to that child's attention, and I think he would find some other way to shorten that hose rather than bring that knife to school.
Well, that's what I understand, but I'm just thinking then he, his car is totally broken down. He takes Dad's car, and Dad's got a toolbox with a knife in it, and he didn't even think of that, because it wasn't what he was used to having. I just don't want innocent kids to be entrapped, basically, when we've got an opportunity fixing this code, by not fixing it thoroughly enough. But I do really appreciate what you're bringing forth, and hopefully you would consider taking a look at that aspect as well.
Thank you, and I share your concerns. The genesis of this bill was from my experience in dealing with a child, a kid 14 years old, who, in my opinion, was a good kid, never been in any trouble before, but got trapped in a bad system. And though the principal took the appropriate actions, the vice principal contacted the school resource officer, and the SRO did their own investigation, and that's where the decision was made to arrest this child.
Thank you. Mr. Levitas.
Thank you, Mr. Chairman. And let me just, maybe I inartfully stated, as I usually do, my comments. And what I'm not suggesting that we get rid of all the notwithstanding language. I'm just suggesting that we narrowly tailor it to the specific circumstance that we're dealing with. Because if you look at the code sections to which that notwithstanding language refers, it allows you to take a child into custody to protect the persons or property of others, if they may abscond or be removed from the jurisdiction of the court, if they have no legal guardian, to protect the jurisdiction and process of the court, reduce the likelihood they may inflict serious bodily harm on others during the interim period, protect the accused from imminent bodily harm upon his or her request. And my concern is that by having this broad language, what we're doing is we're saying none of those would apply in those situations. And again, I go back to my belief that unless there's a standing order in the court, that's the only time you would be able to have that hearing, and there may not be. We've already heard testimony of standing order. But even if you did, you would be capturing way too much conduct, and I don't understand why we wouldn't narrowly tailor that notwithstanding language to address a situation that all of us agree Senator Jones is trying to capture. And my only concern is that we may be in a position where they wouldn't be able to detain an individual even under those circumstances, because we've said, notwithstanding that, unless there's a hearing, you can't detain them.
Those points are well taken, and that goes to the nature of this collaborative process. So, I mean, maybe the DeKalb delegation could possibly come together on some language that hits on the intent. I mean, there is an issue as to whether or not that, is perhaps broad in its application. Is it casting a wider net than necessary in order to get to where you want to be, and then tying in Judge Boggs's points before and making sure that we're hitting on the proper terminology and the proper structuring of the sentence as well, and that's just a function of drafting. So,
may I ask one more question?
Sure.
I just want to get clear in my mind. We're talking here about the Tweety Bird knife that may be in, so you have a zero tolerance policy. We're not talking about armed robbery, or robbery by snatch, robbery by force, none of that.
Absolutely
right?
not.
Okay,
Absolutely
thanks.
Mr. Ramsey.
Just so I guess just to clarify for me, if we didn't do Section 1 and we just passed Section 2, the young man in Morgan County.
That's correct.
Morgan County. The situation that occurred, it would have been prevented if we would have just if Section 2 would have been law. Correct.
That is correct.
Okay. Thank you.
Thank you for bringing that up.
Ms. Abrams. Okay. Mr. Setzler.
Mr. Chairman, I'll make it quick, but I just wanted to use this as an opportunity to directing the senators. I think the underlying concerns here, we as a state, I think rightly allow 16 qualified, competent 16 and 17-year-olds to operate automobiles. We allow them to drive to school and park in parking lots. I would submit that, perhaps even irrespective of this bill, I would submit that driving an automobile on the interstate or on any public road is the automobile itself is a weapon of much greater damage and potential than hand tools. And that I think we as a state, and I'm not looking to address it in 299 to the senator, but I think we as a state, I think we're living a double life if we allow young people to operate automobiles, but not maintain hand tools that could include a Leatherman's tool with a blade to do basic repairs to an automobile. I think it's crazy that we don't have some provision for someone who operates an automobile to have a toolkit that has tools that allow them to work on their vehicle, whether it's putting electrical tape on some kind of tube, some kind of fitting or tube that needs to be worked on in a car. I think there's a broader question here that's not going to be addressed in Senate Bill 299, but I think we as a legislature have to address, to suggest that a 17-year-old in the parking lot of a school, or one of us in the parking lot of one of our schools that we support as legislators, can't have a Leatherman's tool in a toolkit in a car or in the floorboard of a car left there after a repair job is, I think there's a real foundational question we have to address that's not addressed here, but we as a legislature have to address. Because I think the fact that we're holding kids subject to these kind of provisions, I think there's a broader underlying problem than just standing court orders. And I would hope at some point this committee and this legislature could address that.
Thank you, Mr. Mangum.
Thank you, Mr. Chairman. I want to thank the senator for bringing this very important legislation. And I waived in part to hear some of my colleagues to try to understand, because I really, and I will, my distinguished colleague from DeKalb County, I will talk with him afterwards. I clearly do not see what you're saying, Mr. Levitas. But I think that we, in a sense, to piggyback on what my distinguished colleague just stated about the underlying policy decisions, we do need to look at this from the standpoint of not overreaching. I know that we have some Columbine concerns, but I think it is we've gone overboard, and common sense is not so common when we have the situations that have been initiated today. And I just simply want to say that anything that we can do to move this bill, let's do it, including but not limited to having some language that does include local law. But we have to be reminded that the judges, with all due respect, interpret the law. So any legislation that we propose here, the judges will codify in their regulations accordingly. And I know that my distinguished colleague, my former colleague from Coffee County, who is now a distinguished Superior Court judge, has initiated the change in the local rules, but I do understand he's saying that will be new local rules. And if we can just get the intent of this legislation not to catch good kids, and it does simply say a child, caught up into the untenable situations that have been initiated here. And I just want to support this legislation any way we can.
Thank you. Ms. Abrams, last word.
Well, I did not do that.
Mm-hmm.
Oh, there are two of us that are on side by side. I would just ask the senator, given the concerns about Section 1, and this is not a loaded question at all, would your preference be to keep it and try to fix it, or to eliminate it and move forward on the remaining sections, which I think there's fairly broad support for?
And my colleague from DeKalb County, thank you for that. Very good question, by the way. It's my intent to move this legislation forward. And certainly if the will of the committee sees fit to delete Section 1, I am very supportive of moving, because really Section 2 is the heart of this bill. It captures all of those cases that would have been a problem in Section 1. And it would be my intent to move this legislation along so we can get it to the governor's desk as quick as possible.
And so to the chairman, I understand and respect the urge to, because I know this committee, okay, it is my fault, sorry. Exactly. Thank you. Does good work in investigating the nuance. My concern is that because of the complexity of the conversation about local rules versus standing orders, the vagueness of the application, I would recommend, and at the appropriate time would like to be recognized for a motion regarding this legislation with the intent to delete Section 1 and move forward.
All right. What I'm going to do then in that event is I'll yield to the will of the committee, and if we have a motion, we may have a substitute motion at the same time. We may not. I don't know, but we'll just let that process play out. Is there anyone who'd like to be heard briefly, hopefully, on Senate Bill 299? Eric Johns from the Juvenile Court Judges Council.
Briefly, to echo what the senator said, he has been working with Judge Teskey, who basically his statement was zero tolerance, zero intelligence. I think what you've done now is you've given the judges more discretion to handle these cases and to determine which is a serious offense, which is not a serious offense.
That's why we have judges. That's why we have judges. Thank you, Mr. Johns. Anyone else? Seeing none, what's the pleasure of the committee? Ms. Abrams.
I'd like to move to pass Senate Bill 299, LC 294153S.
Ms. Abrams moves Senate Bill 299, LC 294153S. Second by Mr. Mangum. Are there any amendments, Ms. Abrams?
I'd like to move that we delete we delete Section 1, lines 11 through 17, and renumber accordingly.
Ms. Abrams moves to amend delete Section 1, lines 11 through 17, and renumber accordingly. Ms. Abrams moves to delete Section 1, lines 11 through 17, and renumber accordingly. Is there any objection to the amendment? Mr. Sessler.
Perhaps this is a parliamentary inquiry. I want to make sure I understand the effect of that. Again, I need to defer to some of our learned attorneys. The effect of that, what effect would that have on the ability for judges to set standing court orders or local rules requiring that children be detained? In essence, by local rule or standing court order, in essence, having a no-fault policy with respect to detention.
Well, as I understand the current posture as per the Supreme Court, that those local rules are no longer in effect. Is that a correct statement, Judge Boggs?
They sunset at the end of this year, but it's my belief that you can re-up on your local rules. The difference is the old local rules could affect substantive issues like this. The new local rules are going to be limited simply to procedural issues like the creation of mental health courts or the creation of specialty courts, but not affect substantive rights. As I read this, there is a standing order that says, notwithstanding that you are to hold this individual until there's a hearing, or the opposite. This, notwithstanding that you're to let this person out pending a detention hearing, we have a standing order that says you hold it. And that affects substantive due process rights. Apparently that's what's happening. And with this standing order is that the law would have provided that this individual would have gotten out. But by a standing order or local rule, those judges have decided, no, you stay in until we have a hearing.
Well, not gotten out, but would have had a hearing prior to going in. Correct?
That's right.
Right.
Correct. And Mr. Chairman, I asked that question because I think it's certainly a policy objective of mine that there be no standing order. I don't know what the permanency of the what Judge Boggs referred to is with respect to being limited only to procedural matters. I don't know that this is a poison pill that would kill the senator's bill. I certainly want to assist the senator's bill. I believe it's within our purview as a legislature to not do judges' jobs, but in this case I believe to preserve the judicial authority with respect to case-by-case consideration so that they're not these zero tolerance equals zero intelligence kinds of things that are standing out there. I think putting kids in detention is a big deal. It's one thing to sit in the police precinct and sip on a Dr. Pepper while you're waiting on finding out what's going to happen to you. It's another thing to be taken to the Sandersville YDC and having been handcuffed and taken down in a car. I mean, to me, Section 1 is an important part of this bill as anything. And to that end, I think I'm prepared to object to the amendment because I think it's I don't think the senator should cede that ground so easily because I think it's important.
Let me ask the author of the amendment to respond, and then I'll recognize Senator Jones for his thought on the amendment. Representative Abrams.
Thank you, and I certainly appreciate Representative Setzler's vehemence on the issue. My concern is this. We've had 5 attorneys come with 5 different interpretations of a single line. And this body, this committee in particular, I think has a great reputation for deep investigation that can take time. And I think what we've learned from the judge is that this is not as simple as a standing court order, that there are local rules, some of which will sunset, some of which may be re-upped, but that the core of this bill, the zero tolerance policy, is of such important public policy that I would hate to see that have that held back as we investigate the second conversation. I do believe that this is a valuable conversation to have. I believe that it requires investigation, and I think there's an answer to it, and I share both the Senator and Representative Setzler's concerns about the ability of a judge to detain without following due process. But my concern is that I do believe it acts as a poison pill in this committee in terms of the amount of investigation for us to get to a place where we're all very comfortable with it. And so while I do think we could get it done, and I think we could get it done in possibly a timely fashion, I think there is such support for the remainder of the bill, which is why I asked the Senator if he minded taking it off. My recommendation would be that we move the core of the bill forward with the understanding and the intent to investigate what this means, because I'm not certain we understand it, given just the new information we got today from the judge.
Let me offer this. You know, in terms of whether or not the bill moves, the bill's going to move. And it's just, you can quote me on that. The bill's going to move if I've got anything to do with it, because I think it's an important bill. I think we can get to a consensus on that language pretty easily. I just don't want to do it on the fly, as always. But from a practical standpoint, if those orders, I mean, as I understand, those orders sunset at the end of the year, and then any subsequent order going forward is only procedural in nature, as I understand, and so therefore, it really would have we'd have no substantive need for this type of language from January 1 forward. Is that a correct statement, Judge?
I think that's fairly accurate.
Let me ask you to raise your right hand, if you would. And
I'd want to look at the
sure.
statements from the Supreme Court, but I think you're accurate in that respect.
Okay, so I mean,
and the reason for that
yep.
is for this very reason, that those local rules began to start affecting substantive due process rights.
Exactly. So and that makes intuitive sense to me, that if it's if they're going to sunset these, I don't know why they're sunsetting them. I don't know why they just don't eliminate them.
It is
but
the Supreme Court.
All right, sorry. So the January 1 going forward, as a practical matter in terms of due process, you can't have these things. Right. You can't have these local rules, whatever the nomenclature is, from January 1 going forward. So they can't re-up on a local rule that will have a substantive due process problem attached to it that Senator Jones is trying to get to right here. So as a practical consideration, for purposes of January 1, I can't speak to right now to the end of the year, but for January 1 going forward, it's likely a moot point.
Mr. Chairman,
that needs to be explored, and I'm not. I think I'm going on the fly here.
Sure.
Well. I haven't looked at them in 3 or 4 months, but that's my understanding.
Okay. And Mr. Chairman, if I could, I don't know that the presence of an order from the Supreme Court takes away the legislature's responsibility to speak to this. I think it's within our scope to do that. How many kids next fall in the school year are going to be caught up in a no faults policy? I don't know. I think we can only guess. I think the fact that it's not spoken to at all in law is perhaps an oversight. And I would ask if it's appropriate, to Chairman Ramsey, if he's opposed to the policy or just the wording. If we're able to get the consensus on wording, are you concerned with the policy?
Yeah, let me go ahead, Chairman Ramsey. Then I do want to hear from Senator Jones, since it's his bill.
I don't necessarily have a problem with the policy if the application or the understanding of what a standing court order is pretty well defined and understood. But I've asked a number of attorneys. We've asked the judge Judge, what is a standing court order? And he said, well, I think it's referred to as a local rule, but he's on the front lines down there, and he's not sure what it is. So I think by using the terminology that we use here in the bill, there is a potential for a situation of this being misconstrued where somebody that's truly has committed an offensive act or poses a danger is not going to be able to be detained. And I'm not comfortable moving forward given the level of uncertainty among the members of the committee and the learned practitioners in the audience that I've spoken to leading up to this hearing. So Section 2 is critically important. My preference would be to support the Abrams Amendment and strip out Section 1, and let's move forward with Senator Jones' bill. If it's the pleasure of the committee to hold it over and try to see if we can fix Section 1 and get a better understanding, that's fine, but I would vehemently oppose moving the bill forward as is right now.
Senator Jones, let's hear from you, then I think we'll go ahead and make a decision on going forward.
Well, thank you, Mr. Chairman, and I respect the opinions of the members of this committee. And again, as my hope is to focus on the core of this bill, which is Section 2, and that really speaks to zero tolerance and the abuses that we've seen across this great state regarding those particular policies. Section 1 was put in there, was added when I first met with Legislative Counsel because of this particular incident up in Morgan County. But it's my understanding after speaking with Judge Teskey and other members from the Juvenile Justice Council that it's unusual to have these type of orders in place. And that particular order in Morgan County was rescinded. And if it's to practice in the industry, and again, I'm not an attorney, I'm a business person, where these particular orders are not used as a general practice, and as the judge quoted, that they sunset end of this year, then I'm quite comfortable with stripping out Section 1 and moving the bill forward.
All right, Chairman Ramsey wanted one more comment, then we'll move to a resolution.
And I think the question that I asked to Senator Jones, will this, the situation, the egregious situation that happened that you referenced, it would not have happened if Section 2 would have been law. I think that says a lot. I mean, we're getting at the fundamental genesis for the bill, which is that zero tolerance policy. I think Section 1 is a completely different policy matter entirely, and it's something that's certainly worthy of discussion, but I just don't want to weigh this bill down. I want to make sure this gets done into the governor's desk.
All right. I think we're going to go ahead and move forward. There's an amendment on Section 1 to delete Section 1, lines 11 through 17. I think we've had some good conversation on the practical considerations and effect of the state of things now and where they'd be at the end of the year with these local rules. There's an amendment to strike Section 1, lines 11 through 17, and renumber accordingly. There's an objection to the amendment. Let me ask all in favor of the amendment. Okay. Okay.
I just need to understand, Mr. Chairman. Are we saying we basically don't have any time between now and whenever next we meet to try to remedy the concerns that Chairman Ramsey and Mr. Levitas have, as well as the mover of this amendment, to try to at least address
all right, let me ask your question.
This issue?
The answer to your question is, do we have time? Of course we have time. We absolutely have time. There's a motion of due pass. There's an amendment that's been proposed. There is an objection. If there's a substitute motion to table, we'll go ahead and take that up, and to allow for enough time to flesh through it. We may go back to exactly where we are before, but then go through the process that we go through, because that's what we do in order to make sure that we're arriving at the preferred result in the preferred process. So if there's a motion to table right now, I'll go ahead and entertain it.
I would only enter such a motion if it is very clear that we do have enough time to, at the next meeting of this committee, that we address this.
We have, and I've stated that, and it's the chair's intent to have this bill come back at the next full committee meeting.
I would so move at the appropriate time.
All right. There's a motion to table by Mr. Mangum. By Mr. Mangum. Is there objection to the motion?
Object.
There's an objection to the motion to table. All in favor of the gentleman's motion to table signify by saying aye.
All in favor?
All in favor of the gentleman's motion to table signify by saying aye.
Aye.
Opposed?
No.
The motion is not carried.
Mr. Chairman, I withdraw my objection to this motion as well.
There's the objection on the proposed Abrams amendment to delete Section 1, lines 11 through 17 is withdrawn by Mr. Setzler. Is there any objection to the amendment by Ms. Abrams of deleting Section 1? Is there objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments, Mr. Franklin?
I've got two. The first one is on lines 51 and 52. Delete, starting with the word second, delete second or subsequent adjudication or delinquency based on a violation of Code Section 1611-127.1 or is a first. So that those two lines will read, C.2 constitutes a violation of Code Section 1611-127.1 involving.
Mr. Franklin's amendment is to have essentially to have lines 51 to 50 through 53 read constitutes a violation of Code Section 16-11-127.1 involving. Is there objection to the amendment? Sure.
To the author of the amendment. So you are suggesting that if a young person brings a machete to school but doesn't doesn't commit an assault with it, then that wouldn't be a violation of this code section. Is that accurate?
That would be accurate.
Okay, then I object.
There is objection to the amendment. Are there any further questions of the author, by the way, of the amendment? I didn't mean to speed things up too much. Mr. Setzler.
Mr. Chairman, I'm just trying to understand the way this is put together and the reference he makes, 1611-127. I'm trying to understand how it accomplishes what Mr. Ramsey or what Chairman Ramsey had said.
Well, if you read the definition of a dangerous weapon, it's basically a whole host of mortar, bazooka. There's a whole host of weapons, but it doesn't include knives or bladed instruments. By removing a second or subsequent adjudication of delinquency, you are what you're doing in effect is saying, but the first time you bring a machete to school, but you don't commit an assault with it, or a 2.5-inch knife, as the case was, you're going to get you're not going to be treated as a felon. If we pass this bill, the person that does it the second time does get put into that category. It basically gives you a one free bite at the apple, kind of the unknowing mistake. Under the Franklin Amendment, unless you bring one of these weapons that are specifically prescribed as dangerous or a firearm, i.e. the machete, you could never you would never be in violation of this unless you committed an assault with it. So I understand the butter knife in the car scenario, and I'm sensitive to that, but I'm also sensitive to a kid that brings throwing stars or machetes or samurai swords to school. So I would object to the amendment, and again, this is another issue maybe we can work on in the interim to try to get to Representative Franklin's concerns.
And Mr. Chairman, I asked the question because I'm as I indicated earlier, I have an interest in, I think, some of the concerns that Chairman Franklin has. I'm not sure if I were to vote with him what the effect of that would be. I think I may be with him in spirit, but I'm uncertain of that. So out of an abundance of caution, I'm probably inclined to not support his amendment. But I think upon further consideration, I might be prepared to support an analogous amendment to the point I made earlier. So I just want to make sure we understand what we're voting on.
All right. The proposed amendment is lines 51 through 53. It strikes everything beginning with A, constitutes a second. You'd strike A through the word first.
Or second to the word first.
I'm sorry. The word second on line 51 through the word. Thank you. But you asked me what the amendment was, and that was, so it would read constitutes, it would say constitutes a violation. That's what the amendment, as I understand, Mr. Franklin has described.
That's correct. So that then if the person does have their Leatherman tool in the car, and they have not assaulted anyone with it, then they're not in violation. Obviously, we're keeping firearm, we're keeping dangerous weapon unscathed, and they're there anyway. But the idea of anything else, as long as you're not misusing it, then what's the issue?
All right. Let me call for a vote on the Franklin amendment. All in favor, say aye.
Aye.
Opposed?
No.
The amendment fails. Are there any further amendments?
I have the second amendment.
Mr. Franklin.
To just add, if Jill could plug in the upon signature, effective upon signature language, particularly since we've the whole purpose of the bill is because of the standing orders, which stay in place until January 1st, and I don't think we want innocent children to be nabbed between the governor signing the bill and the beginning of a 6-month period after that, that which he might not sign it depending on when we adjourn till after June 1st, which would take it to January 1st as an effective date as it is now. And I think out of an abundance of caution to protect our children, we should have it effective on signature.
Second motion.
Is there any objection to the Franklin amendment to make the effective date of the new law to be on the signature of the governor?
Object. Oh, on the signature of the governor? Sorry.
Okay. Ms. Cooper withdraws her objection. Is there any objection to the Franklin amendment making the effective date of the new law to be signature of the governor? Hearing none, it's adopted. Any further amendments? Seeing none, any further discussion? Seeing none, on the lady's motion of due pass by substitute of Senate Bill 299, LC 294153S, all in favor say aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Senator Jones.
Thank you, Mr. Chairman. Thank you, members of the committee.
Yep.
Okay. I swear that was not my fault. I did want to make one correction to my comments earlier and to apologize to the chairman. This is a committee that I think always...
I think you just have a bad connection. Why don't you pull that one over there?
Thank you.
And put that other one as far away from you as you can.
Exactly. And I'm trying to be... No, I just wanted to apologize. I did not want to suggest that this committee would not be willing to act in a timely fashion. That wasn't my intent, but I did want to recognize the urgency and the importance of this bill, and so any misstatement, I want to apologize.
No, I appreciate that, but I didn't take it that way. I don't think anybody else did either, but thank you.
Mr. Chairman, I believe
Yes,
Representative Ernest Coach Williams has agreed to carry the legislation.
Yes, sir, that's my understanding.
Thank you.
We'll make sure of that. We'll call Senate Bill 112. I know Senator Smith is out of the Capitol, and he let us know that ahead of time. Let me call on Representative Setzler to give us a brief subcommittee report on their action on Senate Bill 112, and then after that I want to recognize Ms. Travis. She and I discussed there's one small issue having to do with lines 30 and 31 that is very surmountable, but Chairman Setzler.
Thank you, Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. SB 112, brought by, again, Chairman Smith from the Senate, simply seeks to add an additional 50% penalty on top of fines for certain violations to help fund special courts. We've added, there's already an additional sum regarding a subset of offenses. He simply adds to these offenses. The bill is largely as it came through the Senate, with the exception of lines 30 and 31. The subcommittee made an amendment that dealt with sums required by subsection A of this code section may be paid in monthly increments upon good cause shown by the court. There was concern of indigent defendants being subject to payments they couldn't afford to fund these courts. So there's just a relatively modest amendment made in subcommittee.
Is that lines 30, 31?
Lines 30 and 31. That was an amendment made in committee. I think Representative Abrams made that, and it was adopted unanimously by the subcommittee. Is
that, Ms. Travis, you and I discussed that as a practical matter. That's already done, isn't it?
Well, yeah, as a practical matter, anytime there's a fine, which has all the add-ons, there's like 21 add-ons, is one of them, and the person has a period of time to pay it, whatever the term of probation is, they pay their fine over. There's a priority listing of fines of how, when somebody makes a partial payment, how that is collected. My concern was if you put that this is to be paid only in increments monthly upon good cause shown to the court, what about all the other fines and fees that have the add-ons and that language is in there? And are you creating different standards?
Special carve-out.
Versus the other fines and fees, and so.
And Mr. Chairman, there was an attempt, and I think the subcommittee, had that been introduced, might have been open to that concern. There was an attempt to not be overly specific. There was discussion about whether DUI courts should be specified, but under current law, DUI courts are a subset of drug courts. So we left the broader drug court language, and again, the intent here is to raise fees to fund the creation of these drug courts in circuits that are not currently don't have them. They exist, as I understand, in I think there are 14 or so of these in the state, and they're looking to expand these, and this fee would allow that to happen. I think Representative Abrams wants to speak to the council's concern on 30 and 31.
And that's why my concern about the priority listing and the other fees that would not have this language.
As the author of the amendment, the intent was twofold. One was to not capture any of the other standing fees, because we understood there were some that those fees were paid in different increments and at different times, but it was only to apply to the additional 50% penalty. It was not to apply to any other fees. So it was only this additional 50% penalty fee that was going to be allowed to be paid, not in lump sum. And so the actual amendment is not the amendment that we passed. The amendment that we passed actually specifically stated that it was only with application to the additional 50% penalty. And I'm not sure if that solves the problem that you're raising, but the intent was not to capture all fees associated with these crimes, because we thought that was overly expansive.
Right.
But we did want to capture the additional 50% penalty.
The only place it says subsection A of this, required by subsection A of this code section, the only place the 50% fines are talked about is subsection A of this code section.
Right, but wouldn't this language, my concern was, and perhaps I misunderstood what you said when I came in, was that this would raise the concern that this would apply to any of the fees that are described in code section A? Or does it only apply to the...
No, do you mind if I repeat myself?
No, not at all. I just and maybe also go to the point of, as a practical matter, it's permissive, and as a practical matter, the courts can allow the monthly increments anyway. Isn't that right?
Yes. A fine that's added, and the judge is here, can explain how it's done with probation. There's a fine, then there's these 21 add-ons, and then you go to probation, and they figure out a payment schedule. They collect the money. Let's say it's a $400 fine, and with the add-ons, it's $600, and you've got 2 years to pay it off. They figure out what it is. When they collect the money and showing Ms. Abrams, there's a priority list. They collect this. By adding that this is just only on good cause shown, whereas it's routine to divide up those payments. That was my concern.
So if I may ask, it's, to accomplish our purpose, we need to not try to fix...
I don't think you need this language.
Okay. As the person who pushed it really hard, I'd be perfectly amenable to removing it.
Okay. The process works, I'm telling you. You know, it's not pretty, but it works. Thank you all for that. Is there anyone here? Again, Senator Smith couldn't be here. He's got business outside the Capitol. He's at a funeral up in North Georgia. Judge, do you want to go ahead and I know you came, for this bill. We'd like to hear from you.
I won't take too much of your time.
I appreciate it. I mean, I think the credibility of these programs speaks for themselves, but your practical experience on the ground and what you see that comes in front of you and how these programs affect people.
One thing, Mr. Chairman, thank you for that, and having been a member of this committee, and I appreciate the diligent and hard work of the committee, and fly-specking, if you will, it makes these bills better, and as a judge that has to determine what you meant by what you said, I appreciate the effort. And first let me speak to what Representative Abrams was attempting to do in 30 and 31. Indeed, the fines that I'll issue, for example, a fine for possession of cocaine in my circuit is typically $1,000. My typical speech will be it's whatever the sentence is plus a $1,000 fine, court cost surcharges, and probation fees. Now, to that $1,000 fine is typically added all these 21 surcharges. There are all kinds of surcharges that are added to it, and just for simple math, you can just about expect that whatever fine I impose will be doubled when it's all said and done. You need to be aware that Department of Corrections regulations and rules provide that probation will divide that up among the number of months that are allowed on probation. So if I sentence you to 5 years for on probation for possession of cocaine, you have up to 5 years to pay it. What they typically do, however, if you're familiar with probation, you go to non-reporting status after 2 years. That's a good thing for the probationer, and so typically what probation tries to do is fit that $2,000 fine in the first 2 years while you're reporting. And if you can do the math, you'll know that the supervision fee is $35 a month. You take the fine of $2,000 total, and basically what your probationer is looking at is about $100 a month to pay off their fine within the first 2 years. Most importantly, I think it is important to make sure everyone here understands this is not a fee. It is a fine. It is a fine charged in response to a defendant having been convicted of an offense. And there is a lot of discussion, obviously, here about what fees are and what they are not. Without opening all of that, exactly. I don't. This is a fine add-on. This bill, the law, has been in effect for in excess of 20 years. When originally passed, this bill, or 15-21-100, only allowed the court to impose this extra 50% for offenses, for 3 separate offenses. It's my considered belief that when the law was passed, the legislature believed, and I think rightfully so, that we ought to make the people that are causing the drug problem help with the eradication and education of the drug problem. It makes common sense, not use taxpayer dollars, but rather make the people that are causing the problem solve the problem. And so when the bill was originally passed some 20 years ago, it only included the violations of 3 offenses: purchase, possession, manufacture, sale, or distribution of a controlled substance, a drug offense; purchase, possession, manufacture, sale of a non-controlled substance, what is that? And trafficking. Trafficking has its own set of statutory fines. For the first offense of trafficking, which by necessity has to be more than 28 grams of the substance. If you have more than 28 grams but up to 200 grams, the statutory fine is $200,000. I'm here to tell you that if you ever ask the Department of Corrections to tell you how much date money has been collected through statutory trafficking fines, the number's basically nothing. Nobody pays that. What happens is I fine them, as I'm required to do. They get put on probation, they get revoked to prison, and when they get out, they're no longer obligated to pay any money. So they don't pay. So my belief is the only offense that we're generating any money on is a violation of Section 16-13-30, which is purchase, possession, or sale of drugs, cocaine, for example. And when I fine an individual $1,000, to that fine is added a 50% surcharge, which is a fine, which goes directly to the counties. That add-on cannot be commingled by your counties. There's a statute that specifically requires it has to be segregated into its own account and can only be used for drug treatment and education. DATE, drug treatment education programs, hence the acronym. So in any event, our counties have this money. They've heretofore traditionally used it for DARE programs. That's kind of where that money came from. But drug courts are becoming more and more reliant on this money because of budget cuts and otherwise, and I think that's really the impetus for the bill, is to make these people that are causing the problem help pay for it. But if we're going to do that, let's identify all of the offenses. And what this does is adds a number of offenses. You don't want me to tell you what all of those are. There are 14 felonies and then DUIs. So that's what we've added, and what we attempted to capture, Senator Smith and I, when discussing this bill, attempted to capture, who are the people that are causing the problem. And if indeed the original impetus for the bill is to make the people causing it pay for it, let's identify the right offenses. So it is a fine, not a fee. It's nothing new. And in the end of the day, it may supplant some federal or state funding that drug courts are in dire need of. And so I would ask for your favorable consideration of the bill. I'm happy to answer any questions.
Mr. Franklin.
Thank you. If you wouldn't mind, I would appreciate you going through the new code sections, whether it be from line 16, 17, but also throw them in on 22, 23, et cetera.
I'll list them in order. I've named the 3 that are already in law.
Right.
The other are, I'll just give the chapter. 30.2, manufacture, distribution, possession with intent, imitation controlled substances. 30.3 is possession of ephedrine or pseudoephedrine over 300 pills or 9 grams. Section 30.5 is possession of a substance with intent to manufacture a controlled substance. 31.1 is sale, manufacture, possession of more than 28 grams of amphetamines or methamphetamines. 32 is transaction in drug-related objects. 32.1 is transaction in drug-related or used objects used to plant or cultivate. 32.3 is possession of just drug-related objects, not tools. 32.3 is use of a communication facility in committing a drug-related felony. 32.4 is transaction in a controlled substance or marijuana in or on or within 1,000 feet of a school. 32.5 is transaction in a controlled substance or marijuana in, on, or within 1,000 feet of a recreational center, housing project, or park. 32.6 is transaction in a controlled substance or marijuana in, on, or within 1,000 feet of a designated drug-free zone. 33 is attempt or conspiracy to commit an offense under this article. Of course, Section 40-6391 is DUI, drugs or alcohol. Section 393 is homicide by vehicle by DUI. That carries 3 to 15 years in prison, in case you're curious. 394 likewise is a felony, serious injury by vehicle committed by virtue of a DUI. And then 3-3-23.1 are the penalties for furnishing, purchasing, or possession by a person under 21 of alcohol.
Thank you.
And those are the new offenses for which we're going to try to generate this fee, fine, if you will, not a fee.
Thank you. As soon as Ms. Barnett gets Mr. Mangum back in here, we're going to go to a motion. That's one way to look at it.
You ought to be aware there are many drug courts, including the one I operate in 4 counties in South Georgia, that do not use a single taxpayer dollar, a local taxpayer dollar. We're funding it with participant fees and date money. You'd be interested to know a lot of counties have accumulated quite a bit of date money because they can't spend it on anything else, and they're not being asked to spend it on the DARE programs and such, and so some of those counties have some funds that we're able to tap into and use for the very purpose, I think, that drug courts are established.
Thank you, Judge. Pleasure of the committee.
Motion do pass. LC 294329S.
Mr. Setzler makes a motion of due pass of SB 112 LC by substitute LC 294329S. Is there a second? Second by Ms. Abrams. Are there any amendments? Ms. Abrams? Okay, I'll make one.
3031.
Oh, yes, sorry. Yes. I'm just having a great day today.
That's all right.
I'd like to move that we strike lines 30 and 31.
Ms. Abrams moves, offers an amendment to strike lines 30 and 31 and to, well, just to strike lines 30 and 31. We don't have to renumber accordingly, do we? Is there any objection to the amendment? Hearing none, the amendment is adopted. Any further amendments? Seeing none, any further discussion? Seeing none, on the gentleman's motion of due pass Senate Bill 112 by substitute LC 294329S. All in favor say aye. Aye. Opposed? No. And the ayes have it, and the motion is adopted. Thank you. Thank you, Judge, for making the trip up here. Appreciate it. We've got one more bill. It's Senate Bill 6. Senator Jackson is at the same funeral that, hold on, can we see if we can maintain a quorum here? Maybe not. 4, 5, 6, 7. Ms. Morse, if you could help me maintain a quorum, thank you. By whatever means necessary. The Senate Bill 6, recall, is the situation where we have a violation on a restriction on a driver's license. What I think we came to a meeting of the minds on with Senator Jackson at our last meeting was that rather than having the decision on a suspension of license rest with the Department of Driver Services, that the preference would be for that decision to be made by a court, and that is to, with regard to treat it like any other traffic offense, that the court would have the discretion to suspend the individual's license if there's any sentencing, fine, etc. And that's the substitute you have in front of you, LC 294340S. The only question I have for Ms. Travis on this particular substitute is I see in the deleted language up above in lines at the end of line 10, the second sentence of the strike-through, I guess. The department shall reinstate the license at the end of 6 months upon receipt of reinstatement fee. Is the effect of that, I don't think the intent here is to go ahead and to eliminate the reinstatement fee. And so I'm wondering if the strike-through there has the effect of doing that. In other words, if we go ahead and if there's a violation on a license restriction, there's a suspension in the discretion of the court. What I don't think Senator Jackson wants to have occur is that if on the reinstatement to eliminate that fee. I also think that might go ahead and endanger the likelihood of his bill being signed should it pass through the process.
Yeah, and I don't, and obviously you wouldn't want to say at the end of 6 months, because it would be at the end of
Right.
change. And I don't know if there is a generic provision in Title 40 relative to reinstatement fees, or if each of the reinstatement fees are embedded within each individual code section. I know
All right.
General Ammons, who is now counsel for PDS, is here. I'm sure she can answer.
Okay. I mean, let's put it this way. As a practical matter, this substitute probably is not what we want to go forward with at this point.
You may want to add, just at the end of line 17, the department shall reinstate the license at the end of the suspension period upon a reinstatement fee of $210 and $210
And just restate the previous language. Okay.
I think you want to move it because, kind of the way I set this up,
Mm-hmm.
you have the kind of the violation there in C.
Right.
Person shall operate. I think that can stand alone. And then D, we're dropping down and have the new D that's talking about this.
Okay, the suspension and then whatever is going to occur in terms of reinstatement and the fee afterwards. Okay. And if there's a representative DDS, we'd love to hear from you. Thank you for taking the time to be here. If you could come forward and let us know who you are.
Thank you, Mr. Chairman. I am Jennifer Ammons. I'm the General Counsel of the Department of Driver Services.
Thank
and
you.
We shared your concern about the deletion of the reinstatement fee. That language was added to the code section last year in House Bill 160, the Governor's super speeder bill. And so there would certainly need to be some consideration of that if it were the intent to take that out. With regard to the language that's been proposed in lines 15, 16, and 17, DDS can operationally transition from the automatic suspension that is imposed upon receipt of a conviction to one that is based upon receipt of information from courts. We've already got a mechanism in place where in other circumstances when a court imposes a suspension as a condition of probation, there's already procedures in place and the courts are instructed on how to provide that information to us. So we would just simply transition the courts from into using that same practice for these situations as well.
Thank you. Ms. Abrams.
I actually had a separate question that Ms. Ammons may be able to answer. My concern is that this now creates unlimited suspensions on licenses, so there is no longer a 6-month maximum that a judge could decide to suspend a license for years. And I'm not sure that there's any language in Title 40 that would put an outer bound on the limit. Am I incorrect, or can you speak to that?
I would agree with you. I would think that there is no set period. Unlike the language that's already in place in Title 17 that allows courts to impose a suspension as a condition of probation for any misdemeanor traffic offense, that is time-bound by the period of probation that is imposed in the sentence. This does not contain any similar boundary.
And so, just in terms of the substitute, my concern is that because of this language, we're creating very, very new law in terms of what a judge can do with a suspension of license, and I'd be very concerned about that.
Sure. I think where the author wanted to go is not, reinvent the wheel, but rather was to, and I mean, if he were here, he could speak for himself. We've had enough conversations, and certainly from our conversation in the last meeting, I think where he wanted to go was to maintain the current law in the context of the suspensions that we're seeing now as a matter of custom and practice, but really was a matter of who decides. And I think that's where I feel fairly certain that's where he was going with it, and wanted to have that in the hands of a judge as opposed to not a judge. And I think then you just have a situation of having the suspension up to 6 months or having some sort of ceiling.
Okay. Then I think I have an amendment.
And maybe the lady could offer an amendment at the appropriate time. Mr. Setzler. Or Ms. Benfield?
No,
we're sharing one because
gotcha,
of my demon.
That's right. Mr. Setzler, I forgot about our rogue microphone.
Mr. Chairman, I was just crafting an amendment to that effect. I think Representative Abrams has got something she's worked on, but just I think I would suggest language that would such suspension for a period of not more than 6 months, and then add the language that Ms. Travis spoke to. The department shall reinstate the license upon receipt of reinstatement fee of $210 or $200 if paid by mail. So,
right.
At the appropriate time, I'd like to be recognized to make a motion and a subsequent amendment.
We'll have the Setzler-Abrams or Abrams-Setzler amendment, as the case may be. Ms. Travis, are you clear on where we're going? Have you all shared that language, Ms. Travis, or have you already got it? Essentially got it. Okay. Oh.
Move.
And so there, Mr. Thank you, thank you so much. Thank you. Eternally grateful. I understand. Thank you, Mr. Franklin.
I had also had the same concerns as Representative Abrams, so
okay,
that I'm taking care of if that takes.
Thank you. I'm sorry, Ms. Travis, but you're. It's getting late. All right. On Senate Bill 6, let's get to a motion. I'm sorry. Is there anybody else who'd like to be heard on Senate Bill 6? Seeing none, what's the pleasure of the committee? Mr. Setzler. I promise you'll be. I promise you'll be recognized for the amendment, but you can't do that. Mr. Setzler moves do pass on Senate Bill 6 LC2, by substitute LC 294340S. There's a second by Ms. Abrams. Any amendments, Mr. Setzler or Ms. Abrams?
I would just say, as we laugh about the motion, there are committees in this legislature that when a do pass motion is made, they are off to the races. I mean, it is literally it's an elbowing match to get to the motion, because when a do pass motion's offered, there's no room for amendment. I know there's broad discussion about Robert's rules, but that's just it is a sight to behold. So I'd like to offer counsel an opportunity to present her language, on which I'm contemplating making a move. Receipt.
Could you repeat that, please, slowly?
Same language as up above.
Well, I mean, on the 6 months, the whole thing, if you would.
Ms. Travis, could you read the whole paragraph, if you would?
Yeah. No rush. I would say, if you would, start on line 15 so we have the whole context.
For a period
of not more than 6 months, and shall report suspension and the length thereof to the department. Which length? Which period? Well, since it's shall determine the length of such suspension, which length shall not exceed 6 months?
You could have something such suspension not to exceed 6 months. Therefore,
for a period,
the top out on it is modifying the word suspension as closely as possible, so that we don't have any misinterpretation problems.
The court shall determine the length of such suspension not to exceed 6 months.
For a period not.
Mr. Thompson.
What if we just added at the beginning, at the end of the first line, suspend such person's license for a period not to exceed 6 months? Put a period and then.
There you go.
I agree.
Outstanding. Good job. Outstanding. You're an example to us all.
Let's give Ms. Travis a few minutes here. No. I just want to make sure you've got it. Is that clear to members of the committee? Does anybody need that repeated back? Is there any objection to that amendment? We'll vote on that in total. Any objection to the amendment? Seeing none, the amendment is adopted. Any further amendments? Seeing none, all in favor of the gentleman's motion of do pass by substitute of SB 6.
Mr. Chairman?
Mr. Franklin.
Since people might get their license suspended since the department is not using the discretionary may on line 10, I think out of the abundance of caution to protect the people of the state, I would like to offer an amendment to use the effective date upon the governor's signature on this one as well.
Let me ask you about implementation. I work for a big company, and sometimes regulators think that we can just go ahead and flick a switch and make a change, in-house, and everything will be fine. I know that there are sometimes implementation challenges. Council, tell us what you think about that.
If we could make it effective on July 1st, that would be helpful. Just doing it upon signature without knowing if there are going to be changes as this continues to make its way through the General Assembly, it would be virtually impossible to have the programmers ready to just literally have it ready to flip a switch.
As a practical matter, let's say we're essentially April 1 right now. I don't know where we're going to be on the budget. Let's say as a practical matter, sine die is April 20th. The governor has 40 days to sign or not sign. That puts us under that scenario at about June 1st. So that in and of itself only gives you 30 days if we sine die at April 21st or so. So, as a practical matter, they need some time for implementation.
Well, and my concern is, even with that language, if he doesn't sign the bill till after July 1st, then what happens? If we delay in adjourning sine die, and he uses his 40 days.
I can't. That's a scenario that I that's throwing the dice on exactly when we'll be adjourning sine die. I have to reasonably presume. I think we have to reasonably presume that we're going to adjourn sine die in a timely manner later than in other years for obvious reasons. Yeah, but he'll have 40 days to sign or not sign. He's not going to not sign. I can guarantee you that.
Right. My concern, though, is the reason why we have this bill in the first place is since the department is not using its discretion and is blanketly suspending for 6 months.
I understand what you're saying. I am not sitting here, nor do I think Senator Jackson was sitting there at the previous meeting and indicting DDS for the job that it's doing or not, or the decisions that it's making. The law, as it states right now, gives DDS that discretion. DDS does not go ahead and make the law, make policy. They enforce the policy. So I'd be very hesitant to make an indictment of DDS on it. I think what might be more constructive is for going forward, we're making a policy decision about who decides. We're saying the court should decide as opposed to an executive level agency. It's not a personal thing. It's just what we think is proper policy as per Senator Jackson, the intent of Senator Jackson's bill. So I still think we have to keep in mind the fact that DDS does have to implement it, has to make certain changes administratively, internally, and as a practical matter, they're probably only going to have from the time this bill is signed about 30 to 45 days to do it.
I appreciate what the chairman's saying. I do think that when we adopt the amendment that it's on signature, they're now on notice that they need to start putting things in place so that when it is signed, they're ready. But on a practical note, we do represent the people. We don't represent the departments and agencies.
Well, I understand that, but I also understand that the people are not served well when the bureaucracy doesn't work well. And if the bureaucracy doesn't work well because it has not been given enough time to implement a new law properly, then really the blame is on us and not on the bureaucracy. So I see, we may just have to agree to disagree, but I would oppose the amendment just on purely practical grounds. So on
that might kill it, but I would like to.
No, it's not going to kill it. It's not going to, believe me. I know this committee. It's not going to kill anything. All in favor of Mr. Franklin's amendment to have the effective date be on the governor's signature, all those in favor of that amendment, please signify by saying aye.
Aye.
Opposed?
No.
And the amendment is not adopted. Are there any further amendments? Seeing none, on the gentleman's motion of due pass by substitute, SB 6, LC 294340S, all in favor say aye. Aye. Opposed? The ayes have it and the motion is adopted. Thank you for coming. And we are adjourned. Thank you for your time.